Hope everyone's doing great today. Today, we're going to be talking about hiring and using experts effectively. It's no secret that experts can make or break your IP litigation strategy. There are so many ways that things can go sideways. I can tell you stories about experts who quite literally showed up with suitcases full of binders. I had another expert who was phenomenal outside the courtroom, but when he testified, he got sidetracked really easily and then would launch into long and complex narratives. Neither scenario is great, and neither leads to a winning strategy. I'm John Gross. I'm VP of Sales at Lumenci, and I've been supporting law firms and corporations regarding their litigation and trial strategies for about the last 18 years or so. I want to welcome everyone today. I'm going to be hosting a session on the expert's role in IP litigation. And I appreciate everyone spending some time with us today, especially as holidays are fast approaching and parties are going on. For those of you who might not already be familiar with Lumenci, let me just give you a quick, brief overview. Lumenci is a global consulting firm that helps litigators and IP teams tackle some of the toughest parts of the IP disputes. We dive into technical details like source code reviews and reverse engineering. And then we pair that with economic and damages analysis, which gives clear and actionable insights for our clients. Recent example, we had a semiconductor case where our reverse engineering uncovered some critical evidence, which shifted the litigation strategy and saved our clients millions in potential exposure. What we found is that most teams lose their case long before they enter the courtroom. And it's not because the facts are weak. It's not because the law is unclear. And it's not because the opponents have a stronger case. The reason they lose is because they never unlock the expert advantage. In IP litigation, expert selection can become one of the biggest drivers of cost, strategy, and ultimately success. Today, we're going to break down how to choose the right experts, how to use them effectively, and how to avoid the pitfalls that can weaken cases even long before they reach the courtroom. And we'll show you with the right approach how you can choose an expert who can truly make your case. We saw this recently in an IPA technology matter against Microsoft. There, their expert was credited with helping IPA secure a $240 million verdict against Microsoft. So throughout the webinar, I'm going to walk through a practical playbook that we use here at Lumenci when we help our teams find the right experts and help integrate them into the litigation process. We're not going to talk about theory, but rather we're going to talk about things we've actually seen work in the field. I'm going to have everyone muted during the session, but please feel free to drop questions into the chat. We'll do a Q&A at the end, and we'll be recording the session, so we'll provide a link to the presentation after the presentation. So let's start with the foundation. Choosing the right expert. Most litigation teams spend too much time on credentials and too little time on things that really matter. Things like clarity, like fit, and strategic alignment. Studies have shown that experts with strong education and relevant courtroom experience have a 45% higher influence on case outcomes. When you're evaluating an expert, here's what actually matters. First and foremost, you have to ensure technical mastery. While this seems truly obvious, teams sometimes overlook this critical first step. For example, in a recent mass tort claim over pesticides that were linked to Parkinson's disease, the plaintiffs relied there heavily on a biostatistics professor as their general causation expert. The courts found his methodology unreliable, and it ended up excluding him from from Daubert, um, which dealt a fatal blow to the plaintiff's case. Secondly, you're going to want to make sure your expert is litigation ready. And what does this mean? It means that they can hold up under cross, and they can handle the pressure. As many out there you can attest, being on the stand and cross-examined can be stressful even for the most seasoned professional. But simply remaining calm under pressure isn't quite enough. You're also going to want to make sure that your expert can communicate without lecturing or losing their audience with heavy and complex technical jargon. Further, you're going to want to ensure that your expert has relevant domain experience. For example, a software patent case needs a software expert. A pharma case needs someone who's actually touched real formulation work. I know it sounds somewhat basic, but misalignment here is still one of the most common causes of expert failure. And then finally, you're going to want to engage the expert early. And this is critical. According to data we've seen, cases with early expert input see a 30% higher success rate. If you bring your expert in too late, really what you're basically doing is you're trying to repair a plane mid-flight. So hiring the expert, obviously step one. Step two is using them effectively. And this is where many cases go off the rails. So let's look at some simple rules. First, you're going to want to engage early. When you loop your expert in during the discovery and infringement strategy window, you're able to get their input before you lock in your narrative. Secondly, you're going to want to scope smartly. And what this means is that you should use your expert for direction and not day-to-day execution. Every expert needs support, and this is one of the most overlooked part of the entire litigation process. Your expert shouldn't be doing every technical task. This is certainly not the highest and best use of their time and expertise. Instead, what you're going to want to do is support them with a blended, scalable team that handles heavy lifting. So you leave the expert to focus in on the strategic layer. In fact, we have an ebook on this topic, which drives this point home even further. Experts who spend too much time digging rather than directing oftentimes will weaken their testimony. You also want to make sure that you keep alignment tight across the firm, expert, and consulting team. Lack of coordination will kill any momentum you have. And finally, remember you aren't stuck with your expert, assuming you've engaged early. If things feel off, really trust your instinct and replace the expert early. You don't want to wait until report deadlines or Daubert where you can lose your case. So not supporting your expert with a consulting team is really like trying to prepare for trial with a single post-it note that just says "wing it." It's certainly a bold move, not one that I would suggest you employing. It's not usually an effective one. So let's talk about scale, speed, and cost. How does a consulting team change outcomes? By engaging a consulting team, you're able to shift the bulk of analysis to a blended rate team, which is going to provide real cost savings. This is going to allow your expert to stay focused on strategy and testimony. A consulting team is also going to provide you with scalability, document reviews, code analysis, massive production sets. These are all things that can crush bandwidth, especially if you're relying solely on your expert. You want your experts to be your strategist and not your workhorse. You don't need an expert witness to do more work. What you need them to do is decide which work matters. You're also going to want to avoid last minute surprises, which can blow up your case. Throughout it all, you want your team to remain flexible. Litigation, as we all know, shifts constantly. A consulting team is going to allow you to pivot without breaking the entire expert workflow. And that's how teams truly can win. So let's hit on some of the biggest pitfalls. We talked about it earlier, but it really bears repeating. Not having alignment between technical and legal teams can cause issues that make you lose your case. Likewise, having an expert with unverified credentials or one that overlooks downward readiness can be fatal. Just as deadly, though, on the other end of the spectrum are experts who fail the clarity test. For example, experts who say 50 words, which can be said in 5. That's not who you want testifying. We have an ebook that shows how these mistakes play out in the real world. Mistakes that lead to misinterpreted technical details, weak evidence, delayed strategy, and litigation costs that spiral out of control. We'll be sharing that link for all of you to download free at the end of this session. Okay, I wanted to make sure I left enough time for questions. So we wrapped up the main show here. So let's jump into some questions. I see there are several that are coming through right now. So George asked, excuse me, how early is early when it comes to bringing in a technical expert? Are we talking pre-filing or once the complaint is served? That's a good question. When I say early, really, I mean before your narrative hardens, which usually means pre-filing and before claim charts are finalized. Early expert involvement does a few things for you. One, it validates your technical theory before committing to it. Two, it allows you to spot weaknesses that can be expensive to fix later on. And you want to ensure the complaint reflects a defensible story and not just a guess. Like I mentioned earlier, the data backs this up, showing that cases with early expert input can see upwards of 30% higher success rates. Okay, I have another question coming in from Jessica. She asks, how do you evaluate whether an expert will communicate well in court? They all sound confident in introductory calls, but that doesn't always translate to testimony. Absolutely right. Charisma on Zoom does not equal clarity under cross. I was once involved in a mass tort matter which hinged on damages calculation. We conducted a mock trial and found that some of the jurors were just splitting damages in half because they didn't quite understand how the expert calculated damages. Once we were able to coordinate with the expert on messaging and clarity, we were able to get full damages awarded because the expert was clear, concise, and was able to arm the jury with information they needed to make an informed decision. So there are a few ways to reliably test courtroom communications. First and simplest, just review past testimony. Unlike with investments, in this case, past performance is a great indicator of future results. You should also give your expert a clarity test. Ask them to explain a central concept from your case, and just in plain English. If they can't make you understand, they won't be able to make a judge or jury understand for sure. You should also engage how your expert does. You should also, gauge how your expert does under pressure. Ask a mildly adversarial question. A great expert is going to stay composed and calm in the courtroom, and clarity is going to be complexity every time. Okay, Ryan has a question. What is the biggest sign that an expert will be a downward risk later on? Besides them saying they've used ChatGPT to develop their position, you want to look for inconsistent methodology. Experts really are going to get excluded because they're unqualified. It does happen, but it's rare. Instead, they're going to get excluded because their methodology will shift midway. They don't document their assumptions, or maybe they apply different standards to prior art versus accused products, or simply they overstate their certainty when the data doesn't quite support it. As a simple rule, I always tell clients if an expert can't describe their methodology clearly in one paragraph, they're a potential downward problem. Where less is more, that's a great rule of thumb, especially when it comes to explaining complex concepts. Okay, Jacob asked, how do you handle conflicts of interest and ensure expert independence, especially when the expert has worked with a party or competitor before? That's another good question. Independence isn't just a checklist, it's really a credibility safeguard. Here's a practical approach. First and foremost, run a formal conflict scan early. You're not going to want to wait until an engagement letter. You're going to want to ask for prior engagements, consulting roles, board seats, equity interests, and any informal advisory work. Capture both direct conflicts, things like working for a party, uh, and proximity conflicts, ongoing work with competitors or maybe key suppliers. And then assess materiality and perception. Because sometimes even disclosed ties can be problematic if they appear to bias the opinion. Apply a simple test. Would a reasonable judge or juror question impartiality based on this relationship? If yes, then don't force fit the expert. Segment roles to protect independence. For example, if the expert has useful domain knowledge but poses a proximity risk, just consider using them as a behind the scenes consultant and then select a different testifying expert for frontline opinions. What this does is to preserve strategic value without exposing the case to impeachment on independence. Document independence in the methodology, because independence isn't just a CV statement. You have to reflect it in the work. Consistent standards across accused products and prior art, transparent assumptions, and audit-ready work papers. If an expert can clearly show the same framework applies regardless of party identity, it's going to blunt bias arguments. You should also plan for cross. You want to preempt the your bias line with a concise, fact-based answer. Disclose, explain guardrails, and then point to objectively replicable methods and third-party validation where feasible. For example, reverse engineering replication logs or reproducible damages model. Okay, Kim has a question about alignment. She asks, what's the best way to align technical findings with damages models so the story doesn't break at trial? Yes, I mean, technical and economic narratives drift when teams build them in silos. We briefly touched on that on one of the earlier slides. You avoid this misalignment by interlocking the story early and enforcing version control. Define the theory of value up front. Is the claim technology a driver of demand, enabler, or incidental? That classification sets expectations for a damages model, and it's going to guide technical scoping. Map claim elements to value drivers. For each asserted claim, identify the specific functional contribution in the accused product and then tie it back to the economic evidence. What this does is it creates a traceable bridge from claim charts to technical impact to economic weight. And then co-develop apportionment. Have technical and damages team draft a shared apportionment memo. What's carved out, what stays in, and why. You're going to want to include sensitivity ranges so minor technical changes don't crash the model. You want to have version control and change discipline. So, for example, when technical positions evolve, whether it's reverse engineering, finding a different implementation, uh, this can trigger a damages sync within uh, 24 to 48 hours. And then you're going to update assumptions, exhibits, and language, especially in Rule 26 reports, just to make sure you keep testimony consistent. And then mock test the narrative. I mean, run a short mock, even internal, where one side attacks the gap, saying things like, you say this feature drives demand, show the proof. If the team can't produce the evidence chain in 2 slides, tighten the linkage before disclosures. Okay, I hope that answers the question. We have time for one last question. And Chris asks, how do you avoid overwhelming the testifying expert when you have a massive technical record? Yeah, I mean, this is a trap teams fall into all the time. A testifying expert should not swallow the entire record. That's why you have a consulting team. The consulting team will handle scale, things like code review, document digestion, product comparisons, prior art timelines. Whereas the expert should be reviewing curated findings. They need to work with distilled intelligence, not a mountain of raw material. You want the expert to set strategy, and they should be responsible for identifying themes, strengths, weaknesses, and the technical narrative of the case. You want to jealously protect bandwidth and credibility to allow your expert to focus in on strategy. Okay, we've got a few more questions, but we don't quite have enough time to get to them today. What I'll do is reach out to you directly via email with those responses. But before we close, just a quick reminder, you can download our free ebook, Hiring an Expert in IP Litigation, which will give you a deeper and practical guidance on everything we covered today, whether that's vetting experts to maximizing their courtroom impact. And certainly, if you want to discuss a specific case or need help choosing or managing an expert, always feel free to reach out. I'm happy to connect one-on-one. And finally, thanks for joining today. I know everyone has tightened timelines around the holidays, whether it's parties or end of year work. But I hope everyone got something valuable out of this. I thought it was a great session. I want to wish everyone happy holidays and hope everyone has a great rest of your week. And look forward to talking soon. Thanks so much.